Hope all of you are fine along with your family members.
Thank you, ma'am. We wish
First
the
of
same
all,
on your
I would
side.
like to suggest you, request you, don't move outside of your house without any reason until unless it is not mandatory to move out. And if you are moving out, then please take precautions, mask, sanitizer, etc. Because on daily basis we are getting bad news of many lawyers, even judiciary or judicial officers, staff, etc., which is really hurting. So it's my request to all of you, please take care of yourself, your family, and don't go outside of your house. Please take precautions and natural precautions, not medicines. So let us start with our topic. As we were discussing a day before yesterday about the pleading and drafting. Almost I had told you about the pleadings. However, I stated to you that I'll share the preliminary objections, but due to any reason I could not share. So today I thought before sharing those preliminary objections, I should make you understand about those preliminary objections. What is the basic, you can say, what is basic behind that particular words, that particular lines which we are used to use as a preliminary objections. So I'll not waste your time. I'm sharing a screen of preliminary objections which I will explain you as short, not as whole. Vishwajit, I think you are facing any problem. Am I audible to everyone?
Yes, ma'am. Yes, ma'am.
So I'm sharing, and simultaneously I'll tell you the meaning of those words. So is it visible to all of you? Don't worry, if it is not visible, then I'll share it to you on WhatsApp as well as on your mail IDs. I'm telling you basically what are what are these contents and what it means. So it may be a written statement, it may be reply, it may be written statement, or it may be reply on behalf of the defendant or defense party, defending party basically. So, what are the preliminary objections? We are used to mention at the outset the answering respondent or answering defendant, whatever the case may be, denies all the averments and contents made by the petitioner or complainant in the petition or complaint, except those which are expressly averred to and admitted herein. These these words are very much important to mention in the written statement or reply. You can say these two lines are the set performer. Okay. Thereafter, that this petition is mere an example of convenient weapon in the hands of petitioner who exploited these laws to her undue advantage and harass her male counterpart. Basically, this is a written statement against the petition filed by the petitioner, means female, who is used to seek any, you can say, DV petition or 125 or any other petition with regard to family law. Okay, so these particular lines, para number 1, this is used specifically for female who is the complainant or petitioner, and we are representing here the defendant, and we are mentioning the preliminary objections against the written statement, against the petition filed by the petitioner who is a female. That the petition is a mere an example of convenient weapon in the hands of the petitioner. Who is petitioner? Petitioner is a female, and which is convenient weapon? Convenient weapon is the law provided to the females by our constitution. There are so many laws in favor of the females. If we are representing a male person, then we have to mention this particular line. Who exploited these laws to her undue advantage and harass her male counterpart, and also a mere tool for harassing her husband, parents-in-law, and other family members, and extracting towering amount of alimony as maintenance. Okay, these are set performa you will have to mention. This performa you will have to settle in your mind. In any case of maintenance, if you are representing the husband and his family, with closed eyes, you can write the preliminary objections as this. There is no if and but, there is no need to change. Next is that the instant petition is false, malicious, incorrect, and malified, and is nothing but an abuse of process of law, and it is an attempt to waste the precious time of this honorable court, as the same has been filed by the petitioner just to avail undue advantage. Okay, so there is nothing to understand. There is nothing to understand. These are the preliminary objections which we have to mention in every petition, basically maintenance petition and domestic violence petition, which is used to be filed by the female. Next, the petition filed by the petitioner. Now, from para number 3, we can use these preliminary objections in any other suit, plaint, petition, or complaint when we are representing the defense person or defending person. Okay, that the present petition is not maintainable because the same has not been filed in a proper manner, hence liable to be dismissed and be dismissed. Here you can also add with heavy cost. Okay, that the present petitioner has not approached this honorable court with clean hands, and the well settled law is that who claims equity must come with equity or clean hands. Clean hand doesn't mean she has not washed her hands. Clean hand means she is concealing the material facts, and she is falsely implicating her husband and his family members. Besides that, she is also wrong at her part or to some extent. If she is alleging against her husband and his family member, then हम लोग बोलते हैं ना कि ताली एक हाथ से नहीं बजती है. In that event, we can use these words. If she is stating her husband as wrong, then somewhere she must be wrong. Okay. Next is the present petitioner. This हो गया ये number 3. I think I had missed. 4 and 5 I have told. The present petition filed by the petitioner is false, wrong, manufactured, concocted, baseless, and bundle of white lies, and not maintainable in the eyes of law, hence liable to be dismissed. These words basically cover every allegation which she has leveled against the defendant against her husband. These words we can use against those allegations. Later on, when we will give the reply on merits, then we will elaborate as per these words. Elaborate against his allegations, her allegations leveled against the husband. Got it? समझ में आ रहा है ना?
Yes, ma'am.
Yes, ma'am. Yes, ma'am.
So 4, 5 I have already concluded to you. Number 6. The petitioner is guilty of suggestio falsi and suppressio veri. इसका मीनिंग इसके अंदर ही लिखा हुआ है. Whatever the petitioner has suggested before this honorable court. Suggested means whatever suggestion in her petition or in her complaint she has given before the court, or whatever suppressed or mentioned is wrong. मतलब whatever she has suggested before the court is false and whatever she has suppressed is wrong. Hence the petition is liable to be dismissed with heavy cost. These are basically legal phrases which basically I'm used to mention in the reply or written statement in preliminary objection. This is my own drafted uh, written statement. Okay, that the petitioner wants to take benefit of the wrong done by the petitioner herself, and the law does not allow anyone to his or her take benefit of his or her wrong. Basically, when any petitioner, any female is used to, or any petitioner, I'm not stating any female or male, any petitioner is leveling allegations against the defendants, then we are used to mention these words because there will be some facts also against the petitioner also, na? There will be some facts. So these words concluded that part. Means she is leveling the allegations against the defendant, but she is also wrong, or petitioner is also wrong because she has done so and so things. Basically, the contention which I want to tell you, these legal objections, preliminary objections are used to be mentioned in preliminary objections, and these preliminary objections are used to be elaborated with the facts on mentioned by the party or client to which we are representing in the court. Got it? So, along with this point, in reply on merits, we will have to mention the wrong done by the petitioner against the defendant and his family members or other defendants. Okay. So, what the law says, if the petitioner had also done wrong, then law will not allow any wrongdoer to take benefit of his or her wrong. Thereafter, if in petition or in suit or in complaint there is even a single contradictory statement, then you will have to mention this particular point in the preliminary objections, that the petitioner has made the self contradictory statements in her petition or in his petition, and the same is not maintainable. On one side, I am stating that the defendant is used to reside approximately 2000 kilometers away from me, or 200 kilometers away from my house, and on the other hand, I'm used to say, or I'm saying that sorry, the defendant is used to come and harass me, or the defendant came to my house on such and such point, and matlab, you can say कि if there is any even a single contradiction, you will have to mention this point. Thereafter, if in any case the petitioner is demanding money, it may be any suit, it may be any petition, it may be any complaint. You can say money in the terms of maintenance, money in the terms of compensation, money in the sense of masne profits. Masne profit is a term of CPC. If you will read CPC, then you will get this term and you will learn this term. It is a very, very interesting term, masne profit. If any petitioner is claiming masne profit, and you are well aware that petitioner had done wrong on his part or on her part, then you will have to, and she or he is not entitled for that amount of compensation or maintenance or masne profit, then you can mention this point that the petition has been filed to extort the money from the answering respondent, and the present petition is not maintainable as per law. And it is my system, my own system. I'm used to mention in every para or in most of the paras that is liable to be dismissed with heavy cost, so that this point should be in the mind of the court that these are the legal paras which are preliminary objections against the petitioner, which are wrong, and if it is dismissed, then cost can be imposed upon the petitioner. However, it is the discretionary power of the court. It can level the cost upon the petitioner. Besides the, if it is a criminal case, beside punishment as well as fine, court can impose the cost for filing the wrong petition or the petition which is not maintainable as per law. Next is the present petition of the petitioner is highly excessive, exaggerated, and imaginary one. Hence, the petition is liable to be dismissed. So many times we have seen that many of the lawyers, many of us are used to, if there is a small thing between parties, then we are used to add on more and more, more and more in the petition just to get the concentration of the court. We are used to level more and more false level allegations leveled against the defendant or respondents. So, if we think that the in petition allegations are too much excessive or aggregated or imaginary, then we can mention these points. Okay. Next is that the present petition of the petitioner is not maintainable in the eyes of law, as no cause of action arose in favor of the petitioner and against the answering respondent. Now, when when a case is used to be filed, the mandatory condition is that there should be cause of action. Why I am filing a petition? Because I have been beaten by my family members, or someone has you can say got the possession of my property, or my husband left me without any reason. He's not giving me monetary help, or I need the protection order from domestic violence, whatever relief we are seeking. But in every petition, if we are going to seek any relief, there should be cause of action. Cause of action means any incident, any fact should be there, and not only fact, any reliable fact, any genuine fact should be there upon which we are filing the suit or case to which we are seeking relief. At initial stage of pleading, I told you what is pleading. Okay? If the condition of pleading is not complete, then the case is not maintainable. Supposingly, if A says to court that we had given beatings to me and my leg got fractured on such and such day, but when the notice was served to B, he got surprised because the day of incident, A is telling during the whole month B was not within the jurisdiction of India. He was not in the jurisdiction of that particular area. So in this contention is in this point, this is the contention that for which action or for which fact, for which allegation the petitioner is claiming relief, for which cause of action the petitioner is seeking relief, that cause of action never arose, never taken place. So at that time, we will have to mention this point. Thereafter, the petition is that the petition is narrating a fabricated story. I told you that we are used to mention the word fact. When we are used to discuss the case with the client, we are used to uh, ask that, okay, tell me about your case facts. But why here we are writing that the petition is narrating a fabricated story? Because it is a story. It is a well planned story. These are not the facts. What are the facts? Facts are those contentions or those contents which actually happened. And story is that which had been fabricated against my client. That is why we are used to write down the petition is narrating a fabricated story which is prepared after thought in the body of the petition, which is based on white lies. Hence, it should be dismissed with heavy cost. Got it? Next, it is pertinent to mention here that the present petition of the petitioner is not maintainable in the eye of law as the petitioner is not entitled to get maintenance as per law. Now, why I have written this point? This is a crux. As I told you earlier, these preliminary objections should be elaborated in reply to Paravise. Now we are stating that this petition is not maintainable as per law as the petitioner is not entitled to get maintenance. Why she is not entitled, or why he is not entitled to get maintenance? There are so many judgments, there are so many laws which are against uh, filing of the petition, and if supposingly a female has filed a petition for seeking maintenance and she herself is earning too much money, how she can claim this relief? Okay, so these particular points are used to be mentioned in the cases of maintenance. You can use this particular point in 125 CRPC, maintenance claim in DV petition, section 24 HMA, Hindu Marriage Act, and petition under Adoption and Maintenance Act. Okay, so this particular point, basically wherever the word maintenance is mentioned, or wherever the petition related to maintenance has come, in this case we have to mention this particular para. So next is, it is pertinent to mention here that the present petition filed up by the petitioner only just to harass the respondent and his family members and without any cause of action. Hence, the present petition is liable to be dismissed. Now, we will say why the petition. Now, this is my reply, indirect reply to the court. I'm saying in 13 paras, this petition is so and so, this petition is so and so, is liable to be dismissed, liable to be dismissed. So, why this petition should be dismissed? What is my contention? Besides those points, what is my contention? Why she had filed this petition? Now, we have mentioned this. The petition has been filed by the petitioner just to harass the respondent. It can be husband, it can be any other person, and without any cause of action. This point again we will elaborate from this point. Para number 14 will not end here at the hence the present petition is liable to be dismissed. Then we will start. It is pertinent to mention here that we will mention here the basic contention between both of the parties. What is the reason of a fight, or you can say any uh, bone of contention, you can say. What is the basic bone of contention between both of them? Why she has filed, why the petitioner has filed this particular petition against the defendants and the respondents. Herein, last preliminary objection, we will give the bone of contention as brief. And later on, at the time of reply on merits, we will elaborate as whole the basic contention between the parties. Got it? Hope you got every point. You understand every point, whatever I have uttered to you. Is there any query with regard to these particular points? These 14 points are nothing, just to, you can say, when we were used to study, there were certain rules which we were used to cram. These are the points which we have to cram. Okay, but you will have to apply your mind as per the petition, as per the suit, whatever are applicable or whatever are not applicable. Basically, first 2 points are for maintenance. These will be added. Rest 3 to 14 can be used in every kind of case. It may be any complaint, it may be any petition, suit, or plaint, whatever be. But first 2 paras can be used for maintenance petition. Any query? Is it clear to all?
Where can we
Yes?
mention the prayers? Will we mention the prayer after this, or like
No,
this
no,
is
no, no, no. These are only preliminary objections. Thereafter, you will have to mention paravise reply. Paravise reply is what? Whatever the paras mentioned in petition or plaint, para number 1, you will have to reply as per that. As I told you that every uh, contention or every content of the plaint should be denied specifically. Those will be denied in reply to reply on merits. Okay.
okay?
Basically, in drafting, I'm telling you, first is the title of the court, name of the court, then case number, then name of the parties, then next date of hearing, then written statement or reply to the petition or application filed by so and so and the defendant or respondent to whom you are representing. If it is single respondent, then mention only respondent. If there are 2, 3, 4, then to whom you are representing, then you will have to mention the number of respondent along with his or her name. Then I had mentioned you, we will start, if it is the same case, then we will start from this point. Respected sir, most respectfully as infra, then preliminary objections, then introduction, and then these are the preliminary objections. Okay. After ending the preliminary objections, we will move to paravise reply or reply on merits. Now, what is reply on merits or paravise reply? Supposingly, para number 1 of the petition. Then, number 1, that the contents of para number 1 of the petition filed by the petitioner is are false and wrong, hence denied specifically. If these are completely wrong, then in toto. If these are not completely wrong, then we will have to mention up to what up to what they are wrong, and thereafter you will have to reply accordingly. Reply on merits will be covered. Then there will be legal paras like cause of action or limitation. When you will be in practice, you will come to know. As far as the legal paras are concerned, in legal paras, we are used to mention the para number so and so is legal para, hence need no reply. Okay. If there is something which is a matter of record, means if the petitioner says I have filed or any petition has been filed against the parties to so and so court, in that case we will file the reply, we will mention in the reply that the contents of para number so and so are nothing but matter of record, hence need no reply. Because it is matter of record, I can't say she has filed or not or he has filed or not. Okay. Thereafter we will reach to prayer clause. Okay. Prayer clause is the last stage of the written statement or plaint. Now, what will be the reply of prayer clause? That the last para of the petition is prayer clause, which is false and wrong and denied vehemently while considering sorry that this honorable court may kindly pass the order against the petitioner and in favor of the respondent or defendant while considering the facts and circumstances mentioned in the above written statement or reply. Okay. Thereafter, we are used to mention if we want any compensation, so we can write down that by filing this petition or suit, uh, the petitioner has caused a defamation against the petitioner, and so defendant is entitled to get compensation. We can write it down. In last, we are used to mention pass any other or further order which this honorable court deems fit in the interest of justice. Okay. So this is the basic content, these are the basic contents of written statement or reply. With this regard, if you are having any query, you can ask. No query? Everyone is silent. I think there are two conditions of silence. या तो सब समझ में आ गया या कुछ भी समझ में नहीं आया. So which condition apply upon you? First one or second one?
मैम आप पढ़ा रहे तो ना समझने का तो सवाल ही नहीं उठता.
ये कौन बोला है? अनुपम मिश्रा जी. ओके. नहीं ऐसा नहीं है. आई एम नॉट अ प्रोफेसर बट आई एम यूज्ड टू try to give my best. Aman, you are getting everything. You are not audible.
Yes, ma'am.
मैम
Yes.
मैम जो मेमोरियल मैम हम बनाते हैं मैम वो ड्राफ्टिंग जो हम एक्चुअली करते हैं उससे डिफरेंट है या ऑलमोस्ट सेम ही होता है?
Pardon, I didn't got what you want to say.
मैम लाइक हम लोग जो मेमोरियल बनाते हैं केसेस के फ्रॉम पेटिशनर साइड एंड फ्रॉम रिस्पोंडेंट
Hmm.
मैम वो जो एक्चुअल में ड्राफ्टिंग करते हैं कोर्ट में जो फाइल करते हैं मैम बोथ आर सेम और डिफरेंट?
As I'm getting, you want to know whatever you are learning in your study, whether that particular drafting and code drafting are same or different.
यस मैम यस मैम.
Totally different. Totally different.
मैम व्हाट अबाउट मेमोरियल्स लाइक हाउ
It is just per
it can
forma. It is just per forma that you should learn how you will have to present your case. But what I have shared, the document I have shared, this is my own drafted case. And one more thing I want to tell you, I'm not used to draft the cases from clerk or any other draftman. I'm used to draft my own.
ओके मैम गॉट इट.
Any other thing? Aman, Tejas, Meenakshi, Dhruv, no query.
No, ma'am.
Tejas, I think Tejas left the room. Anyways, let us come tomorrow with a new subject. Let me check because we are at home, so I will be able to give a short time span to the topics. So let me check which topic I can choose. As far as the lengthy and heavy topics are concerned, whenever I was used to be in office, I was used to check the books and all. But still, I'll do for you. So take care of yourself. Don't move outside of your houses until and unless it is not mandatory. Hello. Finally, you will come.
I was here only.
Okay. See you tomorrow. Take care of yourself. Bye.
Thank you.